Good morning. All protocol observed. I just hope that the PowerPoint works. It seems to have a different one. Today I would like to speak about giving content to competent legal representation and to give a perspective from Legal Aid South Africa. Specifically, if I move on, this is the first time in any instrument that the issue of competence has been raised. It's not in any of your instruments. It's the first time that it's come through in the guidelines where it makes reference to a competent lawyer assigned by the court or another legal aid authority. So this session for me is about sharing ideas, and we've got to understand that for everyone there's a context. Context is everything for each country that you're operating in, and we can only share these ideas and what our experiences have been in addressing and giving content to competent legal representation. And specifically, the level of maturity of your legal aid system will determine what you have as a legal quality program and what its contents will be. When we first started, we didn't have this kind of issue. It was left to the individual principal attorney that was managing 10 candidate attorneys. But if you understand how we develop in terms of a legal aid scheme, and you heard Bella Mdaka earlier today, saying we have 128 service delivery points. And the question then arises, how can you ensure consistency in terms of the quality and the competence of the legal representation you have if you don't have systems which you can manage and implement so that you can have all your practitioners aligning to what is required. And so I say to everyone, remember, as Judge Mlambo said at our welcome, Rome was not built in a day. I think the first perspective you've got to look at in terms of delivering quality services, what are the risks involved of not doing so? What are the risks of not ensuring that you have systems in place? Specifically where you have practitioners not having the necessary skills to competently attend to client matters. Specifically, you'll find your way into the law reports, and the paper that we've prepared, and the paper will be part of the memory stick that you'll get, is replete with judgments dealing with the issue of competent legal representation. And we deal with those both from a South African perspective as well as internationally across all courts where they've looked at the issue of what is or what isn't competent legal representation. And if we don't provide it, the main issue for us is reputational damage, and ultimately the credibility of any legal aid system will then be called into doubt where the quality of legal representation is not of the standard that is required. And this then could result in professional negligence claims and ultimately the worst, infringement of clients' human rights. And I think that's the perspective you have to take in understanding why quality and competent representation is so critical. So from legal aid perspective, we've done a whole quality management program which has two main elements that I will deal with this morning, and that's a quality monitoring program, and specifically legal quality instruments is the first aspect I want to deal with. These legal quality instruments set criteria for the delivery of quality legal services. So it says to you, this is what we can expect to find in a file that we look at to ensure at least that there is some preparation, proper consultation, understanding the instructions. And if you go deeper, and we've developed then as a result of what from our practice experience and what we've determined from case law and the shortfalls that have been identified by case law as to what needs to be looked at to ensure that these competent representations. So we've set up two instruments that deal with the criminal legal services, and that's criminal trials and criminal appeals. So this just sets a consistent base for practitioners themselves and then for legal quality file audits and court observations, so that the criteria are consistently applied throughout by the practitioners themselves in understanding what they need to do in their files, in preparations to properly represent clients. And that pulls them through into the audits and the quality audits and the court observations that happen so that they understand the standards that are required. The same goes, and the same instruments are also used for the judicare practitioners. Cooperation partners, we do also have quality standards, although we don't set that they have to implement any of the quality standards we've identified, they can have their own. So once you have the quality instruments, then it's a system of specifically self-audits by the practitioners. So they must ensure that they're adhering to these quality standards that have been set in terms of the instruments that are in place. From there, we have a random selection of files where management, and this is the first part of the audit, is by management, where the Justice Centre management audits files that they've selected randomly and score them in terms of compliance with the requirements that's been set out in the instruments. The regional offices also conduct audits, but this is more from a developmental perspective to understand how they can support and assist both the Justice Centre in improving the quality of their legal standards. And for each of this process, there is practitioner feedback and corrective measures that are implemented, so that you can't just do a review, but you don't give the practitioner feedback that they can understand the issues that they have to address. And also, you need to monitor and make sure that they ultimately do address what are the problems that have been found within the system. Without doing that, quality without monitoring does not take you anywhere. Then there's a second leg to our legal quality audits, and that's the Legal Quality Assurance Unit. They fall under our internal audit unit, specifically our internal audit department, and this specifically ensures independence from management, because our internal audit department and the Legal Quality Assurance Unit report directly to the board. The board approves an audit coverage plan in regard to the Legal Quality Assurance Unit, which says how they're going to cover the practitioners. And our coverage plan currently is that we cover all our practitioners over a 2-year cycle. So you can't do everyone at once in terms of the numbers of practitioners you saw from Vela's presentation. These assessments are then captured on a web page, and findings are then reported to the board quarterly. Specifically, there's also the analysis of the top 5 findings in terms of whether they are improving, whether those are increasing, and then what management's doing to then address these audit findings. There are specific management and practitioner feedback, and then there's a tracking of all of these audit findings to ensure that there's implementation of what management accepted as the recommendations to address the issues in terms of quality. I've gone into some detail in terms of the quality management and specifically the quality instruments and the quality audits, but over and above that, we also have other systems in terms of practitioner management and supervision program, where files on an ongoing basis are supervised, so that the supervisors look at the files to understand what's happening, to ensure that if there are any issues that they're immediately addressed while those files are alive and going, so that any concerns can be addressed. We also have an overall performance management system. Each of our employees across the organization have a performance management contract that is aligned to our business plan, that aligns to our ultimately to our strategic plan, so that they understand what is specifically required from their perspective and how what they do aligns to the ultimate achievement of our strategic objectives as an organization. There's also a practitioner support needs assessment. So with the systems we've put into place, we now also understand that there are practitioners that require different levels of support. So where you have a practitioner that performs well and consistently and at a level that you're satisfied with, means that your supervision of that practitioner can be less, and you can focus your management and supervision to those that need it more, and therefore to improve their quality, so that you focus where you put your efforts according to where the practitioners are in terms of their development. There's also peer reviews, where we have practitioners that review each other and look at their cases, so that they assist each other more from a developmental perspective, but that is then a further oversight from practitioners over themselves in terms of the quality of the services they're rendering within their files. Then I move on to the second aspect, where you have the quality monitoring, but we also then have systems for quality enhancement. Because without that, you've got to constantly improve your practitioners. So the first thing is our legal training and development program. We first have a national legal training program. And this specific program is identified to look at what are the competency requirements of the practitioners for the specific position that they're in. What are they, and to conduct a skills audit on each practitioner to understand what are their gaps in terms of being able to do that, and how do we address the gaps is then to understand those gaps and bring them into our national legal training program. These are mostly then done by contact training on these identified competency requirements. We then have a national program rolled out to all the regions where we will bring practitioners to contact sessions with experts in the various fields that we want to train them. I'm getting red carded. We also have train the trainer programs. E-learning modules is also, which is done on our intranet, where we send out modules where practitioners can go read themselves, and then they have to do an assessment which is automatically scored by the e-learning system. There's also self-learning systems. Overall, we also then take it out into the regions, a regional training program. A lot of that links to the law societies. And then justice-centered training, they identify locally what are the issues that they need to do. And then also legal blogs that we have, where there's monthly articles that they can discuss on topics we identify where there needs to be some issues that have come to the fore in terms of our practice that's relevant to our practitioners, as well as new case law analysis and discussion in terms of recent cases that come. I'm going to leave it at that overall, and we can have further discussions later. Thank you.